So we have an important update in the Vanderstock Frames and Receivers case. The ATF has now essentially revealed that they intend to take this case back up to the Supreme Court for a full merits review on its constitutionality. So let's talk about what is happening. Now, real quick before we jump into the video, I want to ask you guys that if you appreciate this type of 2A content and you want this type of content to get out to more people, please make sure you're liking and subscribing to the channel. You know, about 60% of all viewers are not subscribed to the channel. So subscribing to the channel can really help to grow this channel and get this information out to more people. Also, thank one of the main supporters of the channel, which is First Form. You know, First Form is a new company that jumped on to sponsor this channel, mainly because I've been on a kind of fitness and health journey. I've lost about 54 pounds over the last year and still trying to improve. But one of the main tools that helped me along with the journey was using First Form and some of their supplements. I highly recommend you check out their protein. You know, I use a lot of their protein powder, and then also some of their protein sticks were absolutely amazing. So First Form is an amazing company. You know, they're supporting this 2A content here on the channel. If you guys are interested, check them out using the links down below. And thank you again to First Form for sponsoring this channel. As I mentioned in the intro, in this video, we're going to be discussing an important development in the ATF Frames Receiver case called Vanderstock v. Garland. The ATF was just put on notice that they need to decide quickly whether they want to roll the dice and appeal another 2A case up the US Supreme Court, and the ATF has indicated that that is exactly what they intend to do. The Fifth Circuit recently handed down its decision on the summary and final judgment of this case. The Fifth Circuit panel recently decided and partially upheld a lower court ruling, but also vacated it partially because the Fifth Circuit believed a vacatur of the entire rule nationwide was beyond what the lower court could do. But still, it was a big pro-2A win, and the ATF's Frames and Receivers rule was struck down once again. But because of that decision, the ATF really only has a few options. They can either file for en banc review in the Fifth Circuit, or they can file for review from the Supreme Court, which would mean that the Supreme Court would have a merits case in front of them, which deals with the ATF's Frames and Receivers rule. The other option for the ATF is to simply allow the case to go back down to the lower court, who is simply going to modify the relief that was granted, and instead of striking down the rule entirely, the judge will most likely just limit the scope of that relief. But it will result in the ATF Frames and Receivers rule still being struck down. So the ATF is in a really bad spot. The Fifth Circuit en banc panel will not be in their favor since they recently struck down the ATF's bump stock ban, and the lower court judge there will also not be in their favor because he's already ruled against them multiple times. His ruling will still technically stand, he's just going to change the relief. The only friend the ATF has had recently was in fact the Supreme Court, who issued a 5-4 emergency stay in their favor. And now because of all this, the lower court has asked for an answer on what the ATF plans to do in this case. And you know, they're asking whether or not they're going to appeal, or are they going to take the loss and see what the lower court says. Now, important for understanding what is going on in the Fifth Circuit, what the Fifth Circuit panel recently did, and where this case is going forward, we need to talk about what the Fifth Circuit 3-judge panel recently said in this case. You know, the Fifth Circuit 3-judge panel agreed with the lower court Judge Reed O'Connor that the rule was in fact invalid. However, the Fifth Circuit panel stated that they believed the outright vacatur of the rule that was issued by that lower court judge kind of swept too broadly and went beyond the type of relief that he should have granted. Therefore, they partially upheld the lower court's decision and issued an order remanding the case back down to Judge O'Connor for him to reissue a decision with a more limited scope of relief. Now, that decision was still a huge win. It was still a huge 2A win, because it really still struck down the ATF's rule. It just said that you need to issue a more limited scope of relief, more specific to the aspects of the rule that were challenged expressly in this case. Now, in reaching their decision, the Fifth Circuit stated that ATF, in promulgating its final rule, attempted to take on the mantle of Congress to do something with respect to gun control. But it is not the province of an executive agency to write laws for our nation. That vital duty, for better or worse, lies solely with the legislator. Only Congress may make the deliberate and reasoned decision to enact new or modified legislation regarding firearms based on the important policy concerns put forth by the ATF and the various amici here. But unless and until Congress so acts to expand or alter the language of the Gun Control Act, ATF must operate within the statutory text existing limits. The final rule impermissibly exceeds those limits, such that ATF has essentially rewritten the law. This it cannot do, especially where criminal liability can, and according to the government's own assertions, will be broadly imposed without any congressional input whatsoever. An agency cannot label conduct lawful one day and felonious the next, Yet that is exactly what the ATF accomplishes through its final rule. Accordingly, the judgment of the district court is affirmed to the extent it holds unlawful the two challenged provisions or portions of the final rule and vacated and remanded as to the remedy. So the ATF lost once again, and the only glimmer of hope that they have here is that they can decide to go back down to the lower court to Judge O'Connor for a more limited scope of relief, but they're still going to lose this case. They upheld his rationale, they upheld his opinion, just found issue with the nationwide vacature. What would end up happening is most likely FBC, its members, 80% Arms and their customers, Maximum Defense and their customers, and a lot of the other named plaintiffs would still get the type of protections that they're seeking. The challenge portions of the rule would be struck down. It just would not be a nationwide vacature. Now, the other options that the ATF has is to seek en banc review in the Fifth Circuit. They could go to the Fifth Circuit en banc panel and ask for relief, but the Fifth Circuit has not been their friends. The Fifth Circuit en banc panel recently struck down the ATF's bump stock ban, and that kind of just forced the ATF's hands where they had to seek Supreme Court review. The Supreme Court granted review in the Cargill case, and they will hear oral arguments in February and decide that case before the end of their term. So the ATF doesn't like the Fifth Circuit en banc panel option. They probably don't like the lower court option either, so that just leaves seeking Supreme Court review. Now, what is interesting, if you look at some of the recent filings in this case, is the fact that Judge O'Connor is now asking for the ATF to tell him what they intend to do in this case. In a recent order, he stated that the United States Court of Appeals for the Fifth Circuit handed down its decision on the summary and final judgment in this case. In light of that decision, the court ordered the parties to meet and confer and provide a joint report regarding the status of this case and how the parties intend to proceed. The parties accordingly filed their joint report on December 4th, 2023. Having reviewed the joint report and applicable law, the court orders defendants, the ATF, to file a status report notifying the court if and when they file a petition for a writ of certiorari or seek any other form of review with the Supreme Court of the United States on this case, and when the time for seeking any such review has expired, whichever occurs first. Now, when you look at that Judge O'Connor order, it really shines a lot of light on what is about to happen in this case. The ATF's recent status report that they submitted to Judge O'Connor took the position essentially that Judge O'Connor, re-looking at this case, granting new relief really doesn't matter and is kind of pointless because of that Supreme Court recent 5-4 emergency stay order that they issued in this case. In a 5-4 order, the Supreme Court recently agreed to stay the enforcement of the summary judgment decision by Judge O'Connor while the Fifth Circuit appeal was going on. And essentially they said, until this case makes its way back up to us, nothing can really change as far as the status. Now, really what this means is nothing as far as new relief will actually change until the Supreme Court decides whether or not they want to review this case or not. And the position right now that the ATF is taking is that anything that the Fifth Circuit en banc panel says, or maybe Judge O'Connor will say, no longer matters because that emergency stay will remain in place and nothing will change until the Supreme Court reviews and decides this case. Because of that, Judge O'Connor issued that recent order saying, well, okay, if you're saying you're not going to seek relief from me, that any order from me will not change anything, any order from the en banc panel will not change anything, let me know if you're going to seek Supreme Court review. You're indicating that you are probably going to seek Supreme Court review. Well, let me know and tell me when that deadline is. You need to notify me. You need to notify the court of what your intent is. Now, looking at the basic federal rules for civil procedure and the basic rules here, the ATF has 90 days from the opinion which was issued by the Fifth Circuit panel. And so that means, I believe, around February 7th, the ATF will need to file for Supreme Court review. They could also get an extension of time from the Supreme Court, but the general rules is 90 days, so that would be February 7th. And I think that's exactly what is going to happen in this case. The ATF is taking the position that any new review outside the Supreme Court is pointless now because of that emergency stay order that the Supreme Court issued. So although the Supreme Court emergency orders that were issued really hurt this case initially, it now has almost forced the ATF into a single track back up to the Supreme Court immediately on an actual merits review of this case. We will have to wait and see how the ATF responds, but I also would not be surprised if they seek Supreme Court cert and then also ask for the Supreme Court to hold this case in light of the upcoming Cargill decision, which is set for arguments in February and will be decided by the end of their term. Because Cargill is very important for this case, it kind of set the precedent in the Fifth Circuit for this case. The decisions here are kind of dependent on Cargill, and now the Supreme Court is going to decide that case. So I would not be surprised if they just say, okay, let's stall this case. Yes, we're going to seek Supreme Court review, but then try to put this on hold. So some very interesting developments in this case, in the Vanderstock case, very important for the ATF frames and receivers rules and other rules that are now being litigated, going forward. Hopefully that 5-4 order, with Justice Amy Coney Barrett joining the liberals, with Roberts joining the liberals, hopefully that doesn't end up being the true position that they're going to take in this case, but we'll have to wait and see. And of course, if anything else changes, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.